This is about to be a very important update for every single person who holds XRP or who is generally interested in the Ripple v SEC lawsuit. And that's because a couple of things have changed in this lawsuit, but most importantly, quite a lot of new documents have to come out tomorrow. And so today, I want to give you guys an exact overview of what's about to happen. Having said that, the crypto market is pretty neutral today. I wanted to talk about the comparison with stocks, but obviously we're still in the weekend, so stocks really haven't done too much just quite yet. Tomorrow could be a very interesting day for that one though. Then again, right now, a couple of coins like Luna are doing really freaking amazing. XRP earlier today was doing really juicy. However, if we actually look at our trades right now, even though we're still in some pretty good profit on most of these trades, the fact that right now we are not basically double our money anymore shows me once more that, guys, we should aim to take profit on the trades, not always keep them open, but for example, like I said, not to always get greedy for more and more and more, and sometimes be satisfied. We doubled our money in a day, yet we wanted more, and right now we are back down to only getting about a third of our money throughout a day. Having said that, here's the update, and here's everything that's about to happen. So December 6th, like I just said, is a very big day. And guys, little two steps back, today a couple of things changed, or I should actually say yesterday. The law changed about deliberative process privilege, and what that basically meant was right now the SEC got themselves a couple of nice steps forward in comparison to Ripple as the law changed. And like a couple of lawyers have said, the reason it's a little bit more bullish for the SEC is because they're trying to prove something about the deliberative process privilege, that they can basically keep claiming it, and the law is kind of nice for that side, so to speak. But here's a couple of things coming out tomorrow, as that was the smallest version of what just happened that I could give. Let us talk. 6th of December, deadline for the SEC to comply with most aspects of the court's October 21st order regarding two discovery disputes. Specifically, the order required the following. 1. The SEC, in responding to Ripple's interrogatories, has to specifically identify any term in any XRP sales contract that created an expectation of profits. There are approximately 1,500 contracts. Those answers are due by December 6th. So once more, the SEC has to respond to a lot of Ripple's questions, as interrogatories are basically questions, that are talking about Ripple's sale contracts. There was a very big back and forth about this a good while ago because Ripple claims that the SEC might have not even read their contract. As one of the responses when Ripple alleged that the SEC could not point out to any wrongdoings in those contracts, the SEC replied and said, it's unduly burdensome to read through those all and to give you a really substantial answer, so to speak. It's an interesting one. It's an interesting one to talk about. Point number 2. The SEC has to answer whether efforts by Ripple were necessary to affect any increase in the price of XRP. The answer is due December 6th as well. So this is a question on the basis of, well, did Ripple and all their actions only move the XRP price? What I mean is for XRP's price movement, the only reason Ripple? Of course, the answer to that is no, but the SEC has now put that on paper that that's the case. And those are the two things which are coming out tomorrow, guaranteed. But there's a couple other things. So here's one that's not necessarily tomorrow. The SEC has to respond to 776 requests for admission that relate to Ripple's fair notice defense. But the judge gave the SEC until 30 days after the judge rules on the motion to strike to provide these responses. If the SEC's motion to strike is granted, the SEC won't have to answer those requests. So I'm not exactly sure why that's within this little December 6th list for that matter, because we don't really know when the decision is going to be made on this new, actually it's a very old motion to strike. And so since they have 30 days after that, we have no idea when the end date for this is going to be. Number 4, the SEC has to respond to 309 requests for admission relating to the defendant's defense under Morrison v. Natal Austell Bank Limited, 561, that XRP sales occurred offshore. Those responses are due December 6th. So the SEC really has a lot to do tomorrow. They have to basically respond to Ripple's request here, where they basically want to verify and confirm that a lot of sales that Ripple did regarding XRP happened outside the US, and thus they do not have officially jurisdiction over those sales. Now guys, before we move on, if you haven't pressed that like button yet, make sure you understand that it helps the channel out tremendously. And I think all the people watching a video where I talk about the XP lawsuit are already subscribed, because we've covered this 1,000 times by now. But still guys, if you aren't subscribed right yet, this type of stuff I cover every single day. So if this is something you like and you enjoyed, make sure you subscribe for more, as you'll learn a lot about crypto, I think. 5. The SEC has to answer whether the XP ledger was fully functional when the XRP distribution started in 2013, but there first needs to be a meet and confer, and we don't know if that one has actually gone over already, between counsel for Chris Larsen and the SEC to clarify the term fully functional. We don't know if that meet and confer has already occurred, so we don't know exactly when that question will be answered either. And then last but not least, the SEC answered numerous interrogatories by reference its answers to other interrogatories. They can't do that. Federal Rule of Civil Procedure states each interrogatory must, to the extent it is not objected to, be answered separately and fully under oath. Judge Netburn ordered the SEC to back and clean up the answers in which it referenced an answer in a previous interrogatory and instead answer it separately as required. So I'm guessing right now that this might also have a deadline for December 6th. It might be that they just have to clean it up and answer with no specific end date. But all we do know about the situation is the SEC has to go back and kind of scrap up a couple of answers that they gave and now answer them truthfully and properly. Because before, on some of those answers, they just said, well, this question we already answered here, and they referenced it. It's not allowed. You have to give a proper answer. Now, having said that, there's also a couple of things happening over the next couple of weeks. Here's, for example, January 14th. We do not know if the following has been completed from previous discovery decisions. Ripple was ordered to produce relevant Slack messages involving 22 custodians. Ripple stated that it could take as long as 12 weeks to complete, so we don't know whether that has been completed or is still ongoing. And this is basically where Ripple had a ton of Slack messages internally, and the judge ordered them to hand it over. While Ripple's motion to compel turnover of pre-clearing trading decision was denied, the SEC was directed to provide the defendants any documentation supporting the SEC statement during the August 25th meet and confer that after the formal order of investigation of Ripple was issued on March 9th, 2019. SEC employees could no longer trade XRP. There is no indication whether that has been done, but in the absence of any follow-up motion on the issue, it is reasonable to assume that it has been done. And what this one refers to is the fact that we a little while earlier wanted some more information about whether or not the SEC could internally trade XRP, and if so, until when and what made it change, like what internal policy. So we eventually got wind that it basically all changed on the 9th of March 2019. However, the judge said you can't really ask for those documentations, but what we can ask for is what exactly made them change up. So a lot of things we cannot ask for, but what we can ask for is what exactly was the memo that made you change, so to speak? Like, what was the deliberation between changing it up and making it non-tradable? Because that's basically what I've read right here. But for the rest, most of it was actually denied. They cannot give over all the pre-clearing trading decisions. But the only thing they can give over is, let's quickly see here, the defendants or the documentation supporting SEC counsel statements during the August 25th meet and confer that after the formal order of investigation of Ripple was issued on March 9th. So basically the deliberation behind, again, the decision. So it's kind of nice though. I mean, we get the document even though the full motion was actually denied. And then there's more, guys. It's not everything. There's also a couple of decisions which we're waiting for, and that is the Ripple defendant's motion to compel the SEC to produce certain documents it designated as privileged. And right now, a couple of things changed in that regard, as the DPP is what the SEC is claiming for exactly this. And so right now that the DPP rules have changed a little bit, this might also be affected. We have 2 more days, because that's going to happen on December 8th, where they have to respond and basically give some information on that. So we shall see. The SEC motion for a telephonic conference and order compelling Ripple to search for and produce video and audio tape recordings of internal Ripple meetings, which we're going to see. the SEC's motion to strike. And once more, guys, after the motion to strike is out, the SEC has 30 days to respond to a couple of questions about it. And also the individual defendants' motions to dismiss. We also have those coming up. All right, and then the deadline for the parties to exchange their respective statements of material facts pursuant to Local Rule 56.1 and the pre-motion letters regarding motion for summary judgment was adjourned without any new date, pending resolution of the motion to dismiss and strike. Meaning, right now, we don't exactly know when the next phase is officially going to get rolling, even though we know the expert discovery date, the deadline basically is January 12th. We don't know when the bigger documents have to be delivered because we have to wait on some judge decisions first. But that's a really good thing because we are going to finally make some steps as these two questions, the motion to strike, motion to dismiss, and even the motion to, no, I think those two actually, most importantly. Yeah, they've been going on since the start of the lawsuit, like for a year now. So it's finally some time to, cross a couple of things away. It would mean some real progress instead of like only fictitious. So that would definitely be nice to see. All right, guys, but I don't want to waste too much of your time. That's the update for right now. That's what's going to be coming out tomorrow. A couple of different documents the SEC has to give over. I'm pretty excited for it because, again, I want them to spill their motherfucking beans. And it's about time that we get some juicy updates in the season again, as it's been a freaking month without any updates whatsoever, it felt like. So I'm finally getting back in it, as we hopefully have a lot of cool things to cover. And you guys already know, if there's ever a hearing, I'll tell you. If there's ever anything cool, I'll go live stream it. So make sure you are subscribed to the channel for more of these XRP lawsuit updates.